beginning in the first plan year after September 23, 2010, no pre-existing conditions allowed whatsoever for children age 18 and under, and that same provision comes into effect for everybody in 2014. Currently, HIPAA has a provision that prevents that allows, well, puts a cap on pre-existing condition exclusions of normally 6 months, but this law would do away with them entirely. And HIPAA also has a provision that says if you have a pre-existing condition that you're trying to impose on someone, you have to reduce the amount of the pre-existing condition by the amount of credible coverage they may have. Who here knows what a certificate of credible coverage is under HIPAA? Well, those of you who deal with health plans or have gone from one health plan to another probably do. This is a certificate that you get from your employer that shows you how long you've been on a plan. And you can take that certificate and offset a pre-existing condition exclusion from another plan that you're about to join, as long as there's not more than a 63-day break in coverage. That's your little mini HIPAA portability lesson for today. But pretty soon you will have, that will be useless because there won't be any pre-existing condition exclusions whatsoever. Annual and lifetime, and again, these are all limits that apply. These are all provisions that apply to grandfathered plans as well. Again, beginning 9/23, first plan year after 9/23/2010, plans may not have annual limits or lifetime limits on essential benefits. There is a slight exception to that prior to 2014. There's a restricted annual limit will be allowed as prescribed by regulations. So certain things you will be able to put a limit on. We will find that out, I would suspect, in the next few months. Now, rescissions of coverage for plan years beginning 9/23/2010, well, after 9/23/2010. Plans may not rescind coverage except in cases of fraud or intentional misrepresentation. One thing that occurred to me is that's not addressed in the statute is rescission of coverage because of failure to pay premiums. I have to believe that that still will be in effect. I think it just sort of goes without saying, though it's not addressed in the statute. Okay, this was sort of interesting. Higher incentives allowed for wellness programs. How many are familiar with wellness programs? Okay. Basically, right now, there are two types of wellness programs as far as the Department of Labor is concerned. Standard-based programs and what I call participation-based programs. A participation-based program would be an incentive provided to your employees for participation in a particular, whether it's a health risk assessment or seeing a video series or attending a luncheon on health or even weekly exercise classes, those sorts of things where you basically only have to show up to get the incentive. Well, those are participation-based programs, and those do not limit. If you have one of those, you are not limited by HIPAA in how much the incentive can be that you would provide your employees for participating. For standard-based wellness programs, which include things like achieving a certain body weight, achieving a certain cholesterol count, achieving a certain body fat count, things that participation alone will not necessarily get you there. Those are called standard-based wellness programs, and those actually have a cap. HIPAA capped, or the HIPAA regulations capped the maximum incentive you can get for those things at 20% of the total cost of the coverage. The healthcare reform now raises that to 30%, with the opportunity for the various agencies responsible for interpreting the law to increase it up to 50% of the cost of coverage. So this is good news. This is a nod by Congress to wellness plans, saying we like wellness plans, we want to promote them, we want to make it easier for employers to use them, as I see it. Okay, this is a pretty big change, and one that in Wisconsin has quite a few implications. Dependent coverage, for plans that provide dependent coverage, those plans now must offer dependent coverage for children through age 25, regardless of marital or student status. In Wisconsin, a fully insured plan, and we've included as handout B, an article that we wrote earlier this year about Wisconsin's age 27 rule. In Wisconsin, if you are a fully insured health plan, also includes dental and vision plans if they're fully insured, you must offer coverage for dependents for the most part through age 26. Now, the dependent's marital status may affect that. There are some provisions in that law regarding military people in the military, but for the most part, people look at it as mandatory coverage for dependents through age 26. Now, does the next slide? I just want to see. Yes. Okay. So in other words, based on those two things, you've got a little bit of a discrepancy. In Wisconsin, a fully insured plan has to cover dependent through age 26. Under federal law, it'll be starting basically the first plan year after 9/23/2010, dependent coverage through age 25. So for those self-funded plans, this will be the first time that they'll have to deal with this sort of mandatory dependent coverage. For fully insured plans, if you've renewed, well, I guess for most people who renewed after 1/1/2010, you're already complying with Wisconsin's law because your insurance company has made sure that you are. But if you're self-funded or if you haven't renewed yet, you will be needing to follow the dependent coverage provisions under the federal law. And interestingly, this law modified the tax code such that, and you will see in my article, there's a provision on imputed income. That is, prior to the passage of this law, you had a issue between what the federal tax code labeled as a dependent and what the state of Wisconsin required you to allow coverage as a dependent. In most cases, the tax code says a dependent, or I should say said, a dependent means someone who is either under age 19 or under age 24 and a full-time student. Well, now that has been changed to include dependents all the way through the year in which they turn 26. In the year in which they turn 27, though, they are no longer considered a dependent. So there's a bit of a conflict here between Wisconsin law. There's a little bit of a gap between what Wisconsin law will require you to do as an insured plan and what will be tax-free. That is, if Wisconsin requires that you cover a dependent through age 26 until they turn the date that they turn 27, the federal law says, well, that can be tax-free coverage until the end of the year that they turn 26, but then starting January 1 of the year they turn 27, it's no longer tax-free. This is covered in the article. Just because someone is not under age 19 or under age 24 and a full-time student does not mean they can't be a qualifying relative of yours and therefore also eligible for tax-free health insurance coverage under your plan. If you provide, and this is the case for a lot of parents who have children in school, if you provide more than half of your child's, well, it's not income, but provide more than half of their support for the year, and it is your child, then they are likely to be a qualifying relative, and you can provide tax-free coverage regardless of their age. Christian? Yes, correct.
It's not an automatic imputed income in that year. It could be a qualifying relative still.
That's right. Someone who turns 27 in that year and who therefore no longer falls under this exemption, I call it an exemption, of the tax code, still could be a qualifying relative. And all the criteria for a qualifying relative is in the article. But I think that's, you know, if you're providing more than half of their support, and it's your child, they are likely to be a qualifying relative. And this is one of these things that I think has gotten lost in the shuffle in a lot of this. Just because someone is over age 20, is age 24 or over and in school, doesn't automatically make them no longer a tax dependent. They can still be a qualifying relative. Hillary? Advise most employers to do in that circumstance is to have an affidavit for the employee to sign that for them to attest to you that they're providing more than half of the support, that the person is their child, and whatever the other criteria are, and including in that, if you're lying to me, you will reimburse us for whatever withholding we should have done, et cetera, et cetera. So you're not required to investigate every employee and hire a PI to figure this out. That is the way most employers are dealing with it, is they have the employee take responsibility for it.